Good morning, everybody. Thank you so much for joining us for our estate planning webinar today, focused on special needs trusts. We're just going to give everyone a couple of seconds to pop in, and then we'll get started. Well, good morning and welcome. Thank you so much for joining us today. I'm Betsy Reeves. I'm the marketing coordinator here at Elevate Wealth Advisory. Some of you joining us today know us very well. Others are new here. And so I wanted to just let you know a little bit about us. Elevate is a wealth advising firm, and we grew out of Vickery Financial Services, which was founded almost 40 years ago, 40 years this September, by Chuck Vickery, with the goal of helping people make smart decisions with their money. We do these webinars once a month, and then every month we focus on a new topic. This month we're focused on estate planning, and here at Elevate we don't do estate planning ourselves. We love to refer people to professionals in our area that handle that. And today we are pleased to welcome special needs attorney Dennise Grayson with Oconee Law Firm, and Dennise is going to introduce the special needs family to assist clients by drafting estate planning documents such as wills, trusts, powers of attorney, healthcare directives, and special needs trusts. She represents families in guardianships and conservatorships, assisting with life care plans to help clients or their parents age in place and maintain quality independent living. Dennise is a native of Athens, and she earned her undergraduate degree from Jacksonville University. She worked in Washington, D.C. and LA before she returned home and opened her practice in Oconee County to be near her parents. Before I let Dennise say hello, I'm going to let you know that if you have any questions throughout this presentation today, you'll see a Q&A box as well as a chat box. So feel free to drop your questions down into either of those. And then at the end of the presentation, Dennise will answer those questions. I'll be just monitoring that throughout. And then this webinar is being recorded, and the recording will appear up on our YouTube channel by the end of the day. I'll send you a link so that you can share it with family, friends, or colleagues that might find this content helpful to them. And then I'll just email you out that link. So I wanted to just go ahead and welcome Dennise. Hi, Dennise.
Hi, thank you very much for having me. I appreciate the opportunity to speak about special needs trust. It's one of my favorite areas of law, so I look forward to speaking about that today.
Wonderful. And Dennise is going to go ahead and share her screen, and then at the very end, we'll go ahead and take your questions.
Once again, Dennise froze. Hold on. Share screen.
Very good. We can see your screen now, and you'll just go up to that slideshow in the center and hit from beginning, and we'll get going.
There we go. Is it working now?
It's perfect. Thank you.
Okay, great. Thank you so much, Betsy. And for you all, I am over 50 and I'm a little bit slow on technology, but I'm getting there. So I appreciate your patience. What we're going to cover today is a topic that I know a lot better than computers, and that is special needs trust. I'm going to just sort of go over an overview of what they are, what their purpose is, the types of special needs trusts. There are first party and third party trusts. There are testamentary trust and Intervivos trust. And then we'll go over a few of the considerations, trustees, beneficiaries, and some of the restrictions that apply differently depending on what type of trust. We may also touch on stable accounts and how they are different from special needs trust. So the purpose, or why you would want to have a special needs trust, what is the big picture? The big picture for any family, but especially those with special needs involved in their lives, is to protect the child, or whether it's an adult child or a minor child, but to protect the family member, to protect the money of the family, and also to protect the benefits for that person that needs them. So what is the purpose of a special needs trust? Special needs trust is different than a spendthrift trust or any other type of revocable living trust or family trust. The purpose of a special needs trust is to protect the beneficiary's eligibility for benefits such as SSI and Medicaid. It also can protect the assets from creditors or from the misuse of those funds. And there are 5 types of special needs trust. The first that we will cover is a D4A, a self-settled trust. The second, a pooled trust. We call that a D4C. We have testamentary trust. We have revocable and irrevocable Intervivos trust. The reason we refer to trust as a D4A or a D4C, that's the federal statute that created the exception for the special needs trust. A D4A, it was called the disability trust. And then a D4C is a disability trust self-settled that is managed by a nonprofit. We'll go into that a little bit today. The first distinction of your trust is the source of the funds. So is it a self-settled or is it a third party? And I'll go into what we mean by that. So for self-settled special needs trust, and again, these can be D4A or D4C, it's funded with the assets that are owned by the beneficiary. So whether it's someone inherits assets and it was not put into a trust, it was given directly to them, or someone wins a personal injury lawsuit, or someone just already owns assets when they become disabled by Social Security's definition, then those assets would need to be transferred to a special needs trust. And all self-settled special needs trusts require a Medicaid payback upon the death of the beneficiary. The 2 types I mentioned earlier, D4A, D4C. How that's different for you is that a D4A would have a private trustee, whether it's an individual or corporate trustee, a trust company or bank of your choosing. A D4C is managed by a nonprofit and they pool all the assets together for better investment ratings or returns. And then the beneficiary has their portion of that pooled trust. In Georgia, the most popular is the ARC of Georgia. They manage the pooled trust for Georgia. So the D4A, and this is the federal statute that allows it. If ever you have insomnia, just look up this statute and read through it. 42 USC 1396P, then D4A. It may be established by the individual if they have capacity, by a court order, or by the beneficiary's legal guardian, but it does use the beneficiary's assets to fund this trust. And the beneficiary must be under 65 years old when they set up this trust. They must also meet the Social Security definition of disabled. And there's only one.
Dennise, I think you've cut out. Can you hear me?
I can hear you. You can't hear me? Hello? One per trust. I think we've all frozen.
I can hear you now, Dennise.
Okay. Let's see if I can get my slideshow to move. Okay. And only one beneficiary per trust for the D4A because it's funded by that beneficiary's assets. It has to be irrevocable or irrevocable, cannot be changed once it is signed. It has to be for the sole benefit of that beneficiary. And it must have the Medicaid payback provision that I mentioned earlier. All trusts, special needs trusts, must be approved by the Department of Community Health in Georgia. And for the D4A, you can have a private trustee or a corporate trustee. The D4C, this is the pooled trust. Again, it's established by the person who owns the funds and who is the beneficiary. It's all the same person. The individual accounts are pooled together for investment purposes, and it also must be approved by Department of Community Health. But it doesn't allow for a private trustee. The beneficiary can be over 65. Notice there's an asterisk there. There will be a transfer penalty, but it can be done. And a D4C is a great option for someone that has a smaller amount to put into a trust or where there is no suitable trustee. This particular individual may not have a family member that is able or willing to serve as trustee. And in that case, and they may not have enough to qualify for a bank or trust company. So in that case, the pool trust is a great option. And of course, that sole benefit rule still applies. For third party special needs trust, and remember that's the source of the funds, we generally refer to those as supplemental needs trust. Back in the day, we referred to all of them as special needs trust. We're now kind of more saying supplemental for third party and special needs trust for self-settled. The third party, I skipped a slide, I am sorry, there we go, it's not going. The third party supplemental needs trusts are funded with assets that belong to someone other than the disabled person or the beneficiary. Let's get it, here we go. Sorry about that, got my slides, okay. It can be used for anything other than SSI or Medicaid, whatever they cover is outside. This trust covers anything that they don't cover. As an example of that, if Medicaid will replace a wheelchair every 2 years, but your beneficiary or your family member needs to go deer hunting and they go through their wheelchairs more quickly than every 2 years, this trust can purchase the additional wheelchairs. That's a real example from one of my clients. The supplemental can cover anything that's not covered by Medicaid. Also, the benefits are there are no restrictions on the age of the beneficiary when you set it up, and no restriction on the number of beneficiaries. So if grandma wants to set up a supplemental needs trust to provide for more than one person, she can do that. And she can have this particular person under the special needs portion of that trust. Again, it has to be approved by Georgia's Department of Community Health. Another benefit of a third-party trust is that you can have co-trustees. You can hire a bank, you can hire a professional trustee, you can have Aunt Sue, you can have John and Mary. So you have a lot more flexibility with a third-party trust. However, the beneficiary of the trust may not serve as trustee or as a co-trustee. Also, there is no Medicaid payback at the death of the beneficiary. So if grandma sets up the trust, grandma funds the trust, then she can say, this is for Sally, who has special needs that we want it to provide for under this trust. And when Sally passes away, I want it to go to John and Mary. So it can be established by anyone. It can be grandma, it can be a parent. They may want to fund it with a life insurance policy, so the trust may not actually get funded until that parent is deceased. It can be set up and with the plan to be funded by parents' life insurance or grandma's will, and then Uncle Bob can put it in his will. Hey, if anything trickles down, don't let it trickle to Sally. Let it go straight into her third-party special needs trust. So we often refer to this type of trust as a big bowl that other family members can pour into for the benefit of this particular beneficiary. Here's an example. The parent buys a term life insurance policy. They spend $10,000 on that policy. It has a $100,000 death benefit. They name the trust as the beneficiary. When they die, the $100,000 goes into that trust, and the other children, the other siblings of that beneficiary, aren't looking at their estate, their inheritance getting divided because the policy provided for that family member, and it helps preserve family harmony in that way. And it also makes sure that that beneficiary does not inherit from the parents, therefore does not lose Medicaid benefits due to being over-resourced. As most of you probably know, the resource limit for Medicaid is $2,000. So if you inherit anything that pops you over the $2,000, then you lose your Medicaid benefits. The third-party special needs trust can be drafted to abide by the SSI income restrictions in case the beneficiary is receiving SSI. Assets would not be considered a resource to this beneficiary. When they're paid out, it is considered income. But if you're familiar with SSI and the in-kind support and maintenance, it can be done so that you can receive, the beneficiary can receive almost 3 times as much being funneled through that trust and being provided appropriately rather than directly giving cash to the beneficiary. And a third-party special needs trust can be an Intervivos or Intervivos trust, which just means during your lifetime, or it can be a testamentary trust. And if it's for a spouse, the special needs trust must be testamentary. And that means if you are providing for your spouse and you want to preserve Medicaid benefits for the spouse, then you must do so under your last will and testament. So to say something is a testamentary trust just means that it is inside a last will and testament. And to say it's Intervivos or Intervivos trust just means that it was signed while you were alive, the grantor of that trust. So Intervivos Special Needs Trust is created today, and it could be funded today. It could be funded after you pass away, with that life insurance as one example, a will as another. And a testamentary trust is created in the last will and testament, and then it's funded during probate asset or during probate process, with whether it's probate or other assets. So third party, supplemental. Testamentary is in the will. Intervivos is it's a standalone document. It's a bowl sitting on the counter waiting for someone to pour money into it. On Intervivos trust, It can be revocable during the grantor's life. The grantor is the person who's creating that trust. So in my earlier reference of grandma setting up a trust, grandma is the grantor. Grandma could set it up. Grandma could make it revocable so she could do changes to it during her lifetime. And then at her death, it becomes irrevocable. And also, Uncle Bob or anyone else can pour assets into grandma's trust for the beneficiary. The trust can be named as a beneficiary on life insurance policies, as payable transfer on death, beneficiary on bank accounts, or from a different third party that just wants to fund that trust. They can do it during their lifetime, the third party, or upon their death, their will can name that trust. So that is a pro. It can be named on other things. It can be the bowl that gets filled up. And as I mentioned, it must be a testamentary trust in order to provide for a spouse. That is a Medicaid rule in Georgia. So if it's a testamentary trust, the drawbacks to it are that it doesn't actually get created until the grantor dies and the will is probated. If the will that creates that trust is ever revoked or amended, then those beneficiary designations at the bank or at the life insurance company are now invalidated because it references a trust under the will signed, as an example, March 1, 2000, but you go back and change your will and sign a new one in June of 2002. Now your beneficiary designation names the will dated March 1, 2000, which is not in existence. So it is tricky to use a testamentary trust unless you're diligent in updating everything and making sure that you keep every I dotted, every T crossed. And that trust cannot receive funds from someone else as long as you're alive, because your will doesn't spring to life until you pass away. So as a recap, we have self-settled trust. They have a Medicaid payback. All of them have a Medicaid payback. And it can be an individual or a pooled trust. Self-settled trusts are assets belonging to the beneficiary. So as an example, if I crash my motorcycle and need to be on Medicaid in the future, my assets, my house, my car, assuming that I still had a motorcycle, those assets would have to be transferred into the trust. And then when I pass away, those assets are used to pay back whatever Medicaid spent on me. A third-party trust, that's the trust that grandma would set up or a parent, and that does not have a Medicaid payback. So if grandma had set up a trust for me, when I pass away, grandma's trust directs where the money goes. So it could go to my siblings or children or grandmother's other grandchildren, etc. Anyone that grandma sets up. It doesn't go to pay back Medicaid unless a trustee commingles the trust. So I could have a self-settled trust with my assets, and I could have a third-party trust with grandma's assets. And if the trustee said, oh, well, they have the same beneficiary, let's just put it in one account. Now they have commingled them. And when I pass away, all of those assets, not just the part funded from me, but all the trust assets will be used to reimburse Medicaid. So it's important that you pick the right trustee. Let's talk about beneficiaries for just a minute. Who can be the beneficiary? for the self-settled D4A trust has to be the same person that sets it up or who owns the assets. And they must be under 65 years old. They can still use a pooled trust, but there is a transfer penalty if they're over 65. And it must be for the sole benefit of the beneficiary. What does that mean? The beneficiary wants to go to Disneyland. Yes, the trust can pay for that beneficiary's trip to Disneyland. But the beneficiary can't travel alone. Social Security says yes, the trust can pay for one travel companion. So if you must have an accompanied person, the trust can pay for their expenses to accompany the beneficiary. But what if the accompanied person is mom? Mom has 4 other children that want to go to Disneyland. No, the trust will not pay for the entire family to go on a cruise. Won't pay for the entire family to go to Disneyland. It'll pay for the beneficiary and it'll pay for one accompanying person if needed. Now on third-party trust, they don't have that sole benefit rule. So a third-party trust can have more than one beneficiary. Let's say you have 2 children that have special needs. They can use one trust. And there are no restrictions on that third-party trust as to who gets the money when the beneficiary passes away. Remember, there's no Medicaid payback. Therefore, the funds can go to stay within the family or wherever that person that sets up that trust wants them to go. I mentioned earlier, you want to have the right trustee. So let's talk about that for just a second. Remember, on D4A and third-party trust, you're picking your own trustee. The beneficiary cannot be the trustee. But who is the right person? Is it a family member? Is it a close friend? Do you have successor trustees selected? What happens if your trustee passes away or is unable to serve? Do you want more than one trustee to be co-trustees? In which case you've opened another trap door. Are both trustees, co-trustees, able to act independently from the other, or are you trying to require 2 signatures on everything? Have you selected a trust protector? And what is that? And what do they do? And a trust protector is someone that can do amendments to the trust if needed. One of the examples we like to give is back in the day, special needs trust statute did not allow for clothing to be purchased. Now it does. So a trust protector could amend that trust to maintain eligibility for Medicaid purposes. So they could remove that restriction, because if your trust was written that to say no clothing can be purchased, but the law changed, the trustee still couldn't do that without violating the terms of the trust. Sometimes we put in an advisory committee. It just depends on the family. We put in, is there someone that's supposed to be checking on this beneficiary? And if so, how often? Maybe you want once or twice a year they have to visit the beneficiary. Maybe you want to make sure that if the trustee isn't doing their job, somebody can remove that trustee. And your beneficiary may not have the intellectual capacity or the legal standing. They may be under a guardianship or conservatorship and not have the legal ability to sue to get that trustee removed. So we want to make sure in this trust that we give adequate consideration to how does a trustee resign? How do they get removed? Who replaces them? What happens when it's vacant? Who's serving? What protections are in place to make sure that the beneficiary is being provided for? All the things that keep the parent up at night now need to be considered, discussed, and have some sort of plan in place inside this trust. And does the trustee understand Medicaid and SSI restrictions? No, they can't give the beneficiary $1,000 a month walking around money if that person's on SSI. Can they pay for food and shelter? Not if they're on SSI, but put an asterisk there. It can be done, but it has to be done carefully. The sole benefit rule. I spoke about the trip to Disneyland. How many people can go on that trip paid for by the trust? What about commingling? Does the trustee understand that just because you have a D4A trust and a third-party trust, same trustee, same beneficiary, not the same pile of money, do not put that in one account. And I've already mentioned no distributions of cash to the beneficiary that would mess up with their SSI rules. And also, does your trustee know to keep those funds separate? Nothing like a good novel where the trustee has a little bit in one pocket for them and a little bit in the other pocket for the beneficiary. And then pretty soon they're using this pocket for that and that pocket for this. So you want to make sure that that trustee knows to keep their personal funds separate from the trust funds. And we are talking about protecting assets, family inheritance, cash, the family farm, houses, etc. And then there are tax issues with the trust. So look at this tax rate for just a minute. At the very top category of 10% tax rate, the taxable income on a person would be 10% if they earned under $10,000. Look at the trust side. The trust is taxed 10% when it earns $2,000. And I'm rounding up and down here, but you'll see that $2,600. So at $10,000, an individual would pay 12% income tax, the second box under individual. But at $10,000, a trust would be paying 35% taxes. These are income taxes. So it does make a difference how the trust is drafted, who's alive, who's the grantor, what loopholes we can put in to keep it at the individual tax rate for as long as possible, and to be cognizant that there may be a period of time that this trust is paying a higher tax rate. It may be, but the purpose of the trust, number one, is not to avoid taxes. It is to provide for a beneficiary who otherwise may not have these assets, may not be able to protect and maintain these assets, and would not be able to receive government benefits or Medicaid coverage without the shield of this trust, this fence around those assets. So every family is different. It's a decision to make on the facts, whether or not a special needs trust, even during a period of paying higher income tax, is still the best protective method for the beneficiary. Because Medicaid brings with it not just health insurance, but it brings eligibility for group homes or other facilities, skilled nursing care, waivers, durable medical equipment, things that they would not be able to afford without Medicaid. So even though the taxes can have a negative impact, the trust can be written to minimize that negative impact, but also keeping in mind that the goal is not tax preservation as much as it is preserving the assets and the Medicaid benefits for the beneficiary. There is no one-size-fits-all special needs trust. Every family is different. The family dynamics are different. The family's resources are different. The beneficiary's needs are different. And a special needs trust should be crafted to accomplish the goal in the best way for that beneficiary, utilizing what resources are there and being cognizant of the family dynamics in play. It is just not a one size fits all. It is not 3 paragraphs that can be downloaded and cut and pasted into any other document and then expected to achieve your goal. A one size fits all that also doesn't really fit every family is the stable account. They were originally called ABLE accounts. I'm still having a hard time calling them stable accounts because to me, a stable should be filled with thoroughbreds. But in any event, Georgia's stable account, they are limited. An individual can only have one account. The total contributions to that account cannot exceed $16,000 in 1 year. The total contribution is $235,000. That's the contribution, and it can grow inside that account as long as it doesn't have more than $16,000 per year or a total of $235,000 put into it. It was created under the Section 529. So that is where a lot of the language managing these accounts came from. And I'm going to go over a few touch points about it, and you can see how it doesn't quite stack up to a special needs trust. Okay. Anyone can contribute to the stable account. They are not tax deductible like an IRA contribution, but the income that's earned by the accounts is not taxed, which is like an IRA contribution. It's just you can't deduct when you give to someone else's stable account. The account withdrawals that are used for qualified disability expenses are not considered taxable when you take it out. Hold on, I'm frozen here. I'm trying to get to the next slide. Try this. There we go. Let's see. Common expenditures of the trust fund are, where did I get here? Let me go back. There. Okay, qualified disability expenses. When you take them out, you can use it for education, housing, transportation, assistive technology, a whole list here, legal fees, any type of health, preventative, wellness, administrative, personal support. You can, all those are considered qualified disability expenses, so very similar to a special needs trust. And then a special needs trust, you can also, durable medical equipment. I mentioned earlier about my client that likes to take his wheelchair deer hunting, but it is important to him to go deer hunting with his friends, and his wheelchair just can't quite hold up that long after a few of those muddy weekends. So his trust is able to purchase replacement wheelchairs for him, and that greatly improves his quality of life. Educational expenses, transportation, cable TV or entertainment, and anything that's not covered by Medicaid. And if you're on SSI, anything that is not considered food or shelter. So one thing I want to mention is the parents of a child that would need a special needs trust. The parents absolutely must have a last will and testament. In Georgia, if you do not have a will, your estate will be divided equally among your spouse and all of your children, whether they are minors or adults. So you don't need a will to give to that family member. You need a will to make sure that family member does not inherit outright. Should they inherit outright, they are going to need a D4A or a D4C special needs trust to regain eligibility for their benefits. With a will, you can put in a special needs trust, and then it would be a third party special needs trust, which would park the assets for that family member until their life has ended, at which time those assets, anything remaining, can go to the other family members under your will. So remember that inheritance can disqualify your family member from SSI, and that will terminate their Medicaid coverage. And their Medicaid coverage is not just for the health insurance, but also those other programs that are only for Medicaid recipients. And the will can divert assets into a special needs trust. So when we work with families that have special needs, we talk about several documents that each person needs. We think everyone should have an advance directive for healthcare. That's that living will document. The HIPAA authorization for medical records. A financial power of attorney, which would allow someone access to your finances while you are alive. The last will and testament, which doesn't spring to life until you have passed away. So there's no crossover between a financial power of attorney and a last will and testament. And then a special needs trust, whether it's inside that will or outside the will. And we recommend that you have a Social Security rep payee designation. So should Social Security ever decide that you are unable to manage your funds, including retirement, that you have already designated a person to act as your rep payee, and that eliminates the need for Social Security to freeze any of your income or Social Security benefits. So these documents are done by estate planning attorneys and special needs planning attorneys. Why do I think you should see a special needs attorney for special needs planning? Because Social Security and Medicaid are frequently revising or reinterpreting their rules. And every year we go in and we tweak things because Medicaid has made a change, or Social Security has made a change, or there was a lawsuit that reinterpreted a rule. And now we need to make sure that we are drafting your documents with that hypersensitivity to where that comma is, whether it says and or, because it's a big difference. And if we have to work with guardianships and conservatorships, every probate court in Georgia has their own nuances. So you want to make sure you're working with a legal staff that is familiar with that particular probate court. Because special needs planning, much like your family, is not one size fits all. Every family is different, every beneficiary is different, and every set of assets is a difference. I am going to see if we have any questions. I'm happy to answer them. And I'll see if I can switch back now.
Thank you so much. That was fascinating. I really appreciate you spending the time with us today. We do have a couple questions. Somebody wanted to go back to the third party trust. You mentioned that you had to get the Georgia Department of Community Health to approve it. What does that entail? And is that something that the attorney assists with, or do they have to do that themselves?
No, that is something that the attorney that drafted the trust should have handled for you.
Okay. Okay, very good. And then once a family understands that they have a child with special needs, at what point should they be meeting with the special needs attorney to have everything put in place? How do they get their other family members involved? Like you mentioned, grandma and Uncle Bob. So what's the best way and process for them to go about?
So in my practice, when we work with these families, first of all, when should you meet with or consider this as a plan? I think as soon as you know, because there's no crystal ball to say which parent is going to pass away first, or are all the children going to be over 18 when the parents pass away? So you want to have a plan in place. I recommend, whether it's a special needs plan or someone without a special needs issue, you pull out those documents and read them every 3 to 5 years to say, does this still meet our goal? You also should pull them out and read them whenever there's a significant change. That significant change would be maybe you've added or maybe you've lost a family member. Maybe you've added or lost significant assets. That's the time where you pull those documents out, read through them and say, does this still apply? Do I need to tweak it? And if the answer is, hey, I don't know if this is going to work, then you go back in for a meeting with a special needs planning attorney. We look at what you have, we look at what the facts are now, and we can make amendments or adjustments to it. And you ask how to get the other family members on board. I remember struggling to write a letter many years ago to provide to the family member. And I didn't want my letter to say, hey, please make sure you include little Timmy in your estate plan. But at the same time, we didn't want a well-meaning family member to say, I'm going to give Tim $20,000 to help him because he needs a little more help than my other nieces and nephews. Because a well-meaning family member wouldn't understand that now Tim has been kicked off of his Medicaid benefits and that $20,000 is only going to buy 1 or 2 wheelchairs. So we came up with a letter. My family sent it out, and we provide it to families now if they need it. And sure enough, about a year or 2 later, the family came back and said, Uncle so-and-so got the letter and actually named this trust as a beneficiary. So now what do? So then we were able to accept those funds in the trust, and it went to provide for the beneficiary without ever negatively affecting his benefits. And so it was really rewarding to see that happen, not just in theory, but in practice.
Wonderful. Okay, great. We have one more question. Was the benefit difference between the stable account and the trust account for the beneficiary not losing Medicaid benefits?
Say that again. I'm not following quite along.
Okay. It says, was benefit difference between stable account and trust account is for beneficiary not losing Medicaid benefits?
Oh, the purpose of a stable account is to preserve the benefits. When you transfer funds into a stable account, it does become invisible for Medicaid purposes, just like a special needs trust. The stable account was designed in theory to prevent the need for a special needs trust. When we first attended trainings and started doing trainings with other attorneys on stable accounts, one of my speeches was entitled "The Broken Promise," because they being Congress said they were going to save the day with this stable account. And by the time it got watered down and put into actual legislation, it does not do the things they said it would do. But it does provide up to $16,000 a year to be invisible. It does allow the beneficiary to have direct access. The beneficiary can have a debit card on a stable account, and that is a benefit to the stable account. But it doesn't quite replace a special needs trust.
Very good. And if there's a follow-up to that, just let me know. You can put that in the chat box. We've got one more. So we are older parents of a high-functioning 5-year-old child with autism. It's not clear what his needs will be in the future and whether he will meet the strict criteria of SSI disability when he's an adult. Is there still a good way to plan for his support in case he's unable to live independently or keep a job easily long-term?
Absolutely. We often put in what is called a contingent special needs trust in our estate planning documents. That way it's sort of a switch that's flipped at the time. So when they're 5, you don't know. When they're 19, you're not sure. By the time they're 30, it's pretty clear what their special abilities are going to be and what their options are for being self-sufficient. So we can draft documents that take that into consideration and provide a roadmap. Betsy, you're on mute.
Sorry. Those were all of our questions. If anybody has any follow-up questions for Dennise, you can send them to me at marketing@elevate-wealth.com. And I'm going to go ahead and share my screen real quick to show you some links. One moment. See if this works. Okay, let me know if you can see my screen now, Dennise.
Yes.
Okay, so we've got a YouTube channel that we put all of this information on. So this recording will be available there later. Just go to YouTube and search for Elevate Wealth Advisory, Athens, Georgia, and you'll find us. You can follow Dennise's law firm, Oconee Law Firm, on Facebook, as well as our firm Elevate Wealth Advisory on Facebook, and you'll see all of our events listed on that page as well. If you'd like to subscribe to our newsletter to find out more information about events that we have, you can go to our website at elevate-wealth.com, and down at the bottom there's a link there to subscribe to our newsletter. And then right below that you see marketing@elevatewealth.com for any questions. Then Dennise's and our websites are there as well. So feel free to just reach out if you guys need help with anything at all. And we just so much appreciate you, Dennise, and all this information that you've given us today. Thank you.
Well, I appreciate the opportunity to talk on it. So thank you very much.
Wonderful. Well, I hope everybody has a great day. Enjoy this little reprieve from the hot weather we've had and stay dry. And thanks so much. We'll see you soon.
Have
Bye,
a great
Dennise.
day.
You too.
Bye-bye.
Bye.